discussion for you tonight on the 200th anniversary of the ratification of the First Amendment to the Constitution. We are inspired to this discussion not only by that event and the timing of that, but by the timing of a book written by co-authored by one of our panelists in our defense, the Bill of Rights in Action, and inspired to discuss where we are as a nation in terms of this really quite remarkable piece of a most remarkable document. Our guests, from my right, Bob Ruffo, who is Sheriff of Suffolk County and President of the Massachusetts Sheriff's Association, also a mid-career student at the Kennedy School of Government, where he will add to his law degree and his sheriff's badge and MPA and be the most dangerous man in the Commonwealth of Massachusetts.
That's for sure.
Bob earned his law degree at Suffolk University Law School. As president of the Sheriff's Association, Bob Ruffo represents the interests of the Commonwealth's 14 county sheriffs in matters pertinent to the operation of the state's correctional system. Next to Bob Ruffo is Caroline Kennedy, co-author of In Our Defense, the Bill of Rights in Action. Caroline was graduated from Harvard College in 1980, attended Columbia University Law School, and is now a mother and a lawyer living in New York. On my extreme left, Stephen Breyer, Chief Judge of the United States Court of Appeals for the First Circuit, where he has served since 1980. Judge Breyer still teaches at Harvard Law School and has worked for the Congress, including serving as Chief Counsel of the Senate Judiciary Committee and as a Watergate Assistant Special Prosecutor, among other positions. And on my left, Lawrence Tribe is the Ralph S. Tyler Professor of Constitutional Law at Harvard, on whose faculty he has served for more than 20 years. His latest books include Abortion, The Clash of Absolutes, and On Reading the Constitution. Professor Tribe has been described as the premier Supreme Court litigator of the decade, having argued at least 18 cases before the court since 1980. He's also one of the favorites of those law students who are doing joint degrees here at the Kennedy School and the law school. If we seem a bit long on lawyers, it is because we're into a very contentious and litigious issue. Rights, specifically the rights enumerated in the First Amendment to the Constitution, which was, as I said, ratified 200 years ago this year. Since this is an anniversary, one would expect the celebration. We choose to celebrate in the spirit of the book produced by Caroline Kennedy and her co-author, Ellen Alderman. That is to say, to look at the Bill of Rights in action and ask the question, is the Bill of Rights working for you? So we'll start with Caroline Kennedy and then go to our other panelists for brief statements, and then we'll open it up to what will be a lively discussion with all of you. Caroline?
Thanks. 1987 was the bicentennial of the Constitution itself. And in that year, a poll came out that showed that 59% of Americans could not identify the Bill of Rights. But it was the Bill of Rights that was added to the Constitution to protect the individual against the power of the state. And it affects our lives every day. Every time we pick up a newspaper or watch the nightly news, go home at night and close the door and know that the government or the sheriff is not going to barge it down. That is the Bill of Rights in action. And it also affects some of the most controversial issues that we're debating in our society: abortion, the death penalty, gun control. And I think part of the reason people don't understand, although they can identify certain things in the Bill of Rights, like free speech or something, but they don't realize the comprehensive nature of it, is because they think it's too complicated or too boring and has nothing to do with their life. So my co-author and I, who met in law school civil rights class, decided to go out and talk to people whose lives have been affected by the Bill of Rights. And we went to Northern California and spoke to Indians who were fighting to save their sacred land from a government highway. And a young couple whose home in Appalachia was ransacked by the police. All their papers, their old college exams, their phone book was all taken and turned over to the police and eventually to the Senate. and they fought for 17 years to get their belongings back. A Cuban woman in Miami who fought all the way to the Supreme Court against a sheriff who repossessed her stove. So, but they're not all happy endings or heroes, and some of the people are not very nice, as one Supreme Court justice put it, but they do fight for the rights of the rest of us. And they raise some difficult questions. One is this working? Mm-hmm. How much offensive speech do we all have to tolerate in the name of a free society? And we spoke to a Klansman in Kansas City, a member of the Ku Klux Klan, who wanted his own cable TV show, Kansas City Cable. And he said that he was entitled to that as an exercise of his First Amendment right of free speech. And the opposition was led by Reverend Emanuel Cleaver, a black minister and member of the city council, who believes that there is some speech that is so offensive that we should not protect it with the First Amendment. And he proposed eliminating the entire channel rather than allowing the Klan on the air. Another tough question is what happens when a young woman who herself was a victim of child abuse is suspected of harming her own child, and the authorities ask, "Where's your baby? We need to see it. We need to make sure he's okay." And she says, "I take the fifth." Can the rights of the child and his safety ever outweigh her constitutional right to remain silent? The Bill of Rights doesn't answer these questions easily, and it may not give us answers that we like, but then it's up to us to ask the next question. And I think one of the people that we spoke to said something that I think about a lot. Her name is Tina Hobson, and along with her husband Julius Hobson, was very active in the civil rights and anti-war movement in Washington, D.C. And she was a victim of FBI harassment, of a secret FBI program called COINTELPRO that was designed to harass and intimidate and split the civil rights movement from the anti-war movement. And she fought eventually for 12 years in court and eventually was successful. But she said it's up to each of us to create a government that's close to our heart's desire, because if you don't do it, somebody else will. And I think that the Bill of Rights is there for us, but it is up to each of us to create the kind of a country or government that we can be proud of.
Judge Breyer.
Right. I'm not going to be too critical. I don't want to be critical of Sheriff Ruffo because he's appealing a case from our court to the Supreme Court, double bunking. I don't want to be critical of Professor Tribe because he's really defending our court's interest in an abortion-free speech case. And I don't want to be critical of Carolyn Kennedy because I liked her book. But I will be a little bit critical of Massachusetts because in the National Archives a few months ago, I found a letter written by Senator Leverett Saltonstall to Cordell Hull. He used to be Secretary of State, for those of you who are young. Leverett, it said, this was written on March 3rd, 1929. It said, transmitted herewith is the engrossed copy of resolutions adopted by the General Court of the Commonwealth of Massachusetts on March 2nd, 1929, ratifying the first 10 amendments to the Constitution, commonly known as the Bill of Rights. This action has been taken upon discovering that the Commonwealth never ratified the Bill of Rights. This action will certainly contribute effectively to better public realization of the protections, etc. They represent the true intention of Massachusetts, which sincerely to be hoped that this action, even if 150 years belated, will serve to make this and future generations aware of the deep significance. Not everyone is aware of the Bill of Rights. Right? But the question, I guess, is if you were back then in 1929, did you ratify it too late or too soon? I mean, what would you ask if you could foresee the future? Maybe they should have reserved judgment a little longer. Why? Well, I'd say there are 4 questions maybe that you'd like to know the answer to, and we know some of the answers. To what extent have the Bill of Rights really stopped bad things? Really bad things, not marginally bad things. And I think your book's interesting because you go into a few really bad things. And what's the report card on that? Well, here you may get a difference of opinion. I think probably it's not too bad. I think we've made a lot of improvements. I see the glass is half full. Why? Well, because I brought this, I'm not going to read you the 130 pages in this opinion, but I mean, this is like one of the jails, not your jail, but elsewhere in our circuit, you know, the calabozo, that's where they put people no access, filthy, they stink. The hospital and the prison's been patched with tin cans to prevent rats. And there's 50 pages of findings like that, okay? So it stopped. Your jail was never that bad, but there are others. We have made improvements. The Scottsboro case, which you'll have to ask your grandparents about, happened 100 years ago. You say, well, at dinner, we say, well, what about in Los Angeles right now? What about in Los Angeles and the police beating people up? That's against the Bill of Rights, in case you don't know. That's prohibited. Well, what does that say? I mean, that says that it's not enforced everywhere. On the other hand, I think the publicity and the almost uniform public reaction is pretty positive compared with what it might have been 50 years ago. So I see that glass as half full. Others might say, no, it's just like I had a friend in high school, grammar school actually. His brother, who was very intelligent, and another student in the 3rd grade was putting 2 and 2 is 7, and his brother began to applaud. So the teacher said, why are you applauding, Robin? He said, because yesterday you didn't know it was a number. All right. All right. So I think that's one. All right. We've made progress, and I want to take some credit for that. I can't take personal credit, but I think my institution can take credit. And the institution can take credit because I think it's because we've set up so complicated a system of enforcement through not just the federal but state judiciary, thousands of people, individual lawyers, that it would take 50 years of different judicial appointments to change it in a drastic way. Maybe that's overstated. Maybe that's overstated. It's a good subject for debate. But it's tough to change that system. And we can enforce those rights. Why? Some Russians came to visit us, and the thing they were most interested in my chambers, in my office, they really wanted to know after half an hour of conversation 2 things. They said, first of all, why does the government do what you say? Interesting question. Why does the government do what the judges say? And what I told him about was not Brown versus Board of Education, but Cooper versus Aaron, where President Eisenhower flew the paratroopers into Arkansas to make certain that Governor Faubus couldn't stand in the schoolhouse door. That, I think, is why they do what we say. And I think that was a key event in our history, an important one. And the other thing he wanted to know was, well, can the government put pressure on you? Can somebody call up even the president? A president appointed me. Could he call up and say, do thus and so? I say, no. He's unlikely, any president ever, to reward me. It's very hard for a president to punish me. Therefore, I am rather independent. And he said then, well, what about your wife? All right. So, all right. Now, think, compare. It's not just the words on the paper. Not just the words on the paper. It's the institution we've set up. So, I mean, that's one thing to think about. A second question, I would say, what about rights that aren't in the Bill of Rights? The Bill of Rights doesn't deal really with race. It doesn't deal with a lot of things that are important. It deals with a few things, protections against certain government actions. Well, what about these other things? I like to point to the 9th Amendment because I was the law clerk for Justice Goldberg when he wrote an opinion called Griswold versus Connecticut. He came in one day and said, no, look at the 9th Amendment. Why did he say that? The 9th Amendment says the enumeration of certain rights in the Constitution shall not be construed to deny or disparage others. Justice Black, in dissent, had said there is no right of privacy, no right of marital privacy, because it isn't listed explicitly. And Justice Goldberg's concurrence said, but remember the 9th Amendment. It says don't take the enumeration of some to mean that there aren't others. Don't do that. Who is the only person in history who's violated the 9th Amendment? Justice Black. It's an instruction to judges, you see? And, well then, what rights are these other rights? That's a good question. Professor Tribe will explain it. All right. The third kind of question I want to bring to your attention, because I think it's a good subject of debate. Who are they supposed to protect us against these rights? Before the Civil War, there was little doubt but that they were supposed to protect us only against the federal government. You see, power had been delegated to the federal government. Sometimes you delegate something, and the people you delegate it to get a little carried away. So just in case, we're going to withdraw the delegation. We're going to keep them cabined. That was before the Civil War. After the 14th Amendment, now they're against the states too. They say the states might protect individuals. But ask 50 people on the street, And they'll say the purpose is to protect some individuals against others, against other private individuals? Remember Vanessa Redgrave, a case in our court. What did she say? What did she do? The Boston Symphony Orchestra wouldn't let her perform because she'd supported the PLO. Our court found that a Massachusetts statute which says you can violate a civil right without government action, well, we sent it over to them. It's a little complicated. The upshot is the Bill of Rights doesn't protect you against what some other private person might do. Why not? Well, it's too hard. It's too hard. Could we stop the BSO from censoring Vanessa Redgrave without censoring the BSO? If your father wants to disinherit you because you've joined the PLO, should the law stop him? What about his right to express his view? You see how complicated it is? But the fact that it's complicated doesn't mean you have to forget the underlying value, that the First Amendment is there to protect speech you hate, not speech you like. And there's no reason why the BSO or any other organization couldn't have said, we will let people speak and perform whom we hate, not those whom we like. In other words, it may not be literally applied to private people, but there's no reason it can't be taken as a kind of moral code in terms of the basic value, and indeed we did. The fourth and final question is, what's the future? I predict one aspect of the future. One aspect of the future is there's going to be a lot of balancing of right versus right. There has been in the past, there will be in the future. What do I mean? Remember the man who saved all the people from the Potomac River when there was a crash? A hero. And what happened to him? His name's in the newspaper nonstop, so's his private life. He didn't like it. He objected. He said, why? Because I'm a hero. Should every detail of my private life be on the front page? What's he trying to protect? The right of privacy. How does that stack up against the First Amendment? Where does the law come in? You see, that's the question, not the answer. What we will see is lots of balancing, not right against wrong, but right against right.
And how many questions do you have, Sheriff?
Just one. I'm beginning to get a complex up here, both as a Kennedy School student and as a sheriff. Taking someone's stove away from them, Caroline? My God. Just to try to hone in on a particular issue, since I do come from jail, and Judge Breyer sort of warned me this evening before this forum that if I ever did appear in the federal district court in Boston, that I would definitely be incarcerated with all the trouble that I've caused with this particular case. Where he would send me to a federal penitentiary where I would be double bunked. The issue that I have focused on in our preliminary discussion is the Eighth Amendment, cruel and unusual punishment. And just what is cruel and unusual punishment? And just who is the Bill of Rights trying to protect? Is it protecting the prisoners, or is it protecting the law-abiding citizenry? And when we get into that balancing test that Judge Breyer just alluded to, sometimes the scales tip a little bit to the left or to the right. And depending upon what your persuasion is, people tend to get very emotional about this issue of the public's right to be safe and secure in their homes. And the issue that I've brought to the forefront to the Supreme Court of the United States, which will be heard sometime shortly after the first Monday in October, is just what are the limits of the federal judiciary? What is the federalism issue here? How far should the judiciary go in protecting those rights of the accused, of people who still maintain the presumption of innocence, who have been sent to jail because two judges have made a decision that they pose a threat to society. They are an endangerment to the community at large. And just what am I supposed to do with my statutory obligations, which I was elected to do, which is something that my brothers and sisters here on the stage don't share that same luxury. Not only do I have certain statutory obligations to keep individuals in jail, but I have the people telling me what to do. And when I'm hit with this compromise position of release to the street when you reach a certain capacity, I begin to wonder just what are my obligations to the public when I have a state judge who threatens to incarcerate me for not taking his prisoners and a federal judge who threatens to incarcerate me if I do. That has caused great concern, enough to bring this issue on federal intervention into the minutiae of operations of a public official like me who has certain statutory responsibilities. and this whole issue of just what is cruel and unusual punishment after you build a brand new jail that has a certificate of occupancy for 650, but a federal judge who says, no, no, we should only put 450 prisoners in that jail and continue to ship prisoners around the state to where they wind up being double bunked. So that kind of is it in a nutshell, what the issue is in this particular case, which will have wide scale ramifications when the Supreme Court ultimately decides it.
Thank you. So, Professor Tribe, how would you position this issue? With what questions?
Well, it's all very simple. We just sort of solve all these problems quickly. No, I really am not sure how best to give this focus, and I'm more eager to hear your questions than I am to hear myself speak. So I'll be really as brief as I can. No, not as, I guess I've been as brief as I can already. I'll be almost as brief as I can. I think one of the things that's sort of interesting is that several times when you were describing what we were going to be talking about, you said this was about the First Amendment. It was about the First Amendment to the Constitution. Of course, it's about all 10 of the amendments of the Bill of Rights, but that leads one to wonder sort of what difference does it make which rights we say we're talking about. As Steve Breyer reminds us, many of the rights that are most fundamental, most important, the right to freedom of thought, rights to privacy, rights of a kind that people take for granted aren't mentioned at all in the Bill of Rights. And when you work on bills of rights in other countries, you are quite quickly struck by how the landscape of the world is littered with absolutely gorgeous constitutions and lovely bills of rights that mean almost nothing to any of the people in those societies because they're not meaningfully enforced, because there is no backing of the kind that President Eisenhower finally, and under a lot of pressure, did provide for desegregation. So in the end, the Bill of Rights on paper and a Bill of Rights in life can be two dramatically and radically different things. In a society like ours, quite often, the Bill of Rights is really only on paper. I mean, I'm reminded of these characters who were coming over on the Mayflower, some pilgrims, and they're looking at the distant horizon, and one of them says to the other, as land is sighted, religious freedom is my immediate objective, but my long-term plan is to go into real estate. In a way, that's the history of the 1980s. In a way, it's what becomes often of the Bill of Rights. That is, one of the cases that Caroline discusses at some length in her book involves the rights of Native Americans to their native land and the sacred land in the Northwest. And the Supreme Court has a very lovely text. It says that Congress shall make no law abridging the freedom of speech or the free exercise of religion. I think this thing is falling off. Or the free exercise of religion. And the Supreme Court's reading of that lovely text is that when the sacred lands of the Indians are destroyed, it's only real estate after all, their religious freedom remains unaffected because no one is telling them what to do or what not to do. So there is no free exercise of religion claim in the case at all, even though the government at minor added cost to itself could go around their sacred lands rather than through them. So that the words of the Bill of Rights, even when they are quite specific, even when you don't have to resort to something like the Ninth Amendment and the idea that there are reserved rights that are not enumerated, the words only provide a starting point. And so much turns on whether life is breathed into those words in ways that reflect the claims, the needs of a diverse and of a pluralistic society. Take another provision, the Fourth Amendment, protecting the right of the people to be secure in their houses, papers, and effects. Not long ago, there was a fellow whose house was a space under the overpass in a highway in Connecticut. That was his house. He was homeless. And an argument was made that because he had no house, as the propertied authors and ratifiers of the Bill of Rights would have conceived that term, that he was unprotected by the Fourth Amendment. The police could engage in surveillance and rummaging when he had to leave his pile of belongings without getting a warrant, without having probable cause. Happily, the Supreme Court of Connecticut not long ago decided that the Bill of Rights should be given a capacious enough reading to cover that space under the highway as though it were a house. But that case again illustrates, and I wouldn't at all gamble on how the U.S. Supreme Court would resolve it if they were to agree to hear it, and my hope is that they will not. What that illustrates is that the bare words, even when they seem quite precise, tell you relatively little. Whose Bill of Rights is it? Does it belong to the homeless? Does it belong to the Native American? Does it belong only to the people that the framers had in mind when they wrote those majestic words? It seems to me that in focusing on the meaning of the Bill of Rights in the future, the question with which Steve Breyer left us, that it's terribly important to realize that the spirit that is breathed into those generalities and those specifics will be much more a function of the culture that we as a nation bring to it, the kinds of judges we appoint to enforce it, the kinds of executives we elect, the kinds of sheriffs that we elect to give it meaning from day to day, than the mere grammar or the mere syntax can possibly suggest. Let me suggest one final theme, and that is we've talked so far about the Bill of Rights, and I want to flip it on its side for a moment and suggest that we're also concerned, or ought to be, with responsibilities. I mean, one of the things that strikes me most dramatically in the First Amendment context, to return to the way you began this, is the way in which it's very easy for a lot of people to equate the right of the press, free of censorship, to report whatever it can get its hands on and whatever is in the public domain, with the question of whether it is right for the press to do exactly that. Let me focus just for a moment on something that I suspect will be pretty controversial, and that is on the question of whether the identity of rape victims should be made public. I don't question the right of the press to make public what is already in the police blotter and has found its way into the public domain in some limited way. But what strikes me as bizarre is how a number of people move from the fact that the press has a right to do it to the conclusion that it's wrong for the press to exercise self-restraint. It's been said, for example, that one of the fundamental principles of our system of government is that there should be no anonymous accusation. And that's right when it comes to someone who's standing trial. That person has a right to confront his or her accuser, not to be accused from behind a screen. But that's quite different from saying that the press should feel free to chill and suppress and victimize those who have made a report to the police in a violent and intimate crime. It seems to me that the responsibility of those of us who are enfranchised with such powerful rights oughtn't to be forgotten. It's just not enough to talk about our rights against the government without paying a lot of attention to how responsible we are in the exercise of those rights.
Now we're nearing that point in this evening's program where you all have a right to say something. And to exercise that right, you need to queue up behind these microphones. I'm going to exercise the constitutional right of asking the first question, which seeks really to try to place this issue in a time plane, if you will. There's a piece that I ran across in Harper's in November of 1990, Louis Lapham's piece on the condition of democracy, where actually he was looking at the hypocrisy of many Americans in taking great glee in exporting our democracy, our Constitution, our political tradition and history to Eastern Europe and the Soviet Union, when our exportable goods were not in maybe the best shape that they'd ever been in. And in pursuing that, he wrote this, which I think goes to the question, how do these rights stand up in practice in 1990? He said, the Bush administration cries up a war on drugs and the public responds with a zeal for coercion that would have gladdened the hearts of Puritan judges presiding over the Salem witch trials. Of the respondents questioned by an ABC Washington Post poll in September 1989, 55% supported mandatory drug testing for all Americans. That's higher today than it was in that poll. 52% were willing to have their homes searched, and 83% favored reporting suspected drug users to the police, even if the suspects happened to be members of their own family. Politicians of both parties meet with sustained applause when they demand longer jail sentences and harsher laws, as well as the right to invade almost everybody's privacy, to search without a warrant almost anybody's automobile or boat, to bend the rules of evidence, hire police spies, and attach, again without a warrant, the wires of electronic surveillance. Within the last 5 years, the Supreme Court has granted increasingly autocratic powers to the police, permission without probable cause to stop, detain, and question a traveler passing through the nation's airports in whom the police can see a resemblance to a drug dealer. Again, without probable cause, granting permission to search barns, stop motorists, inspect bank records, and tap phones. Is that the currency of that hard issue, a serious and sustained threat to what we're talking about, the rights we're talking about? And how would that threat be ranked in a continuum of modern American history? Where are we in terms of the threats aimed at the Bill of Rights?
Well, although my glass is now almost 90% empty rather than just half empty, I guess I do think that putting it in perspective, I'm really less pessimistic than Lewis Lapham seems to be. That is, it is true, and certainly that tape in Los Angeles brings it home in a dramatic way. It is true that not everyone enjoys rights that most of the people in this room take for granted. It is also true that people are quite often willing to sell their rights short in the name of some moral equivalent of war, whether the war on drugs or the war on something else. It's also true that one can enumerate, especially in an era when 70% of our judges have been appointed by Presidents Reagan and Bush and have a different reading of the Constitution from that of a number of other people who preceded them, that you can make things seem pretty horrible. But if you just put it in perspective, I mean, prior to 1965, the Supreme Court of the United States had never once found an act of Congress to violate the free speech clause of the First Amendment. Prior to the Civil War, there was nothing in the Constitution that would even be relevant if a state were to execute somebody for practicing a religion, or if a city were to torture a confession out of someone. That is, if you focus on the long picture of American history, I think our general direction of progress is positive. I don't think that we are now at a great apex, and I think we will look back at the present era and see it as a pause in a generally progressive march. But I think it's a progressive march nonetheless.
Yes, Judge?
I would just say to Mr. Lapham, calm yourself, Mr. Lapham, calm yourself. Make distinctions. It's important to make distinctions. Look at the three examples. He said X percent, some very high percent of the people didn't mind if the police searched their house. I don't mind if the police search my house. If there's a crime and you're actually involved in it and you think it would be helpful for the police to search your house, I suspect most of the people, depending on the circumstance, in this room wouldn't mind. And if they do mind, it's all right with me. And if they don't mind, it's all right with me. I think it's up to them. All right, that's example one. Example number two, mandatory drug testing. Well, I think my own feelings and yours may differ. It depends. It depends about who and under what circumstances and when. If you're going to tell me that they're going to have mandatory drug testing of airplane pilots, I think that's a pretty good idea. If you're going to tell me it's every citizen in the nation, I say, gee, that's pretty impractical, and that worries me rather. Okay? Who? When? Under what circumstances? What about turning in your parents and your children? My God, I can't believe it. Now, okay? Now, look at how my own reactions differ. All right, if in fact we take things that are highly debatable, where there are very different views, and it looks at the margin, and we escalate that into cases of the world is coming to an end, then I think we run the risk that when people disagree with us at the margin, the world will come to the end because they won't see the difference between the marginal case and the serious case. So that's why when you read an article like that, I say, calm yourself, make distinctions so that we can distinguish between what's universal and important, the core value, and differences of opinion at the edge.
Yes, sir.
Ms. Kennedy stated earlier that about 59% of the American public cannot identify the Bill of Rights. And my question to the panel would be, is a better understanding of these rights critical to a further bolstering of these principles across the United States? And if so, what are your ideas for creating a better understanding among the American public of the Bill of Rights?
I think it is critical. I think one of the things I've been going around the country talking to people about the Bill of Rights because the book has just come out. And I think that we've heard a number of different things in different communities, and I think people care a lot about it. They don't know what maybe all 10 is, but when something comes up in their local community that involves one of the issues under the Bill of Rights, I think people care a great deal. They support it. They don't want to sacrifice it. And they're very interested in understanding the principles involved. So I think that there's a lot that could be done in terms of making people feel that it actually has something to do with their own life. It's not something that they cannot understand. It can become quite complicated, but basically I think it's something that people do find interesting. For example, we were on a number of call-in shows, and people called in with questions about the war, the restrictions on the press, or people were being told that they had to wear yellow ribbons in school. Their children had to. And there's a famous Supreme Court case that says you can't be forced to wear a black armband, or you can't be suspended for wearing a black armband during the Vietnam War. So I think that there are a lot of isolated examples and ways to make it more relevant to people's lives, and I think that would help.
One point, it's often said that people don't recognize the Bill of Rights. I think the greatest danger isn't so much when they don't recognize it, as when they profoundly reject it. I mean, that is, if enough people over a sustained period of time think that the Bill of Rights is a bad idea, we're not going to have it. I mean, ultimately, it does depend on popular acceptance. So that what kind of worries me is when I see there was a Hearst survey in 1986 which showed that something like, in a fairly large sample, 53% of the people surveyed thought that the president should have the right to suspend the Bill of Rights during wartime. And 49%, I think it was, thought that, of course, people should not have the right to, as they put it, preach revolution. But it seems to me that when you have attitudes of that sort, then you really have a challenge, not so much of informing the public, of what's on this piece of paper. See, the First Amendment says Congress shall not abridge the freedom of speech. But really having a dialogue with people of a sort that I think Caroline's book really helps to do about what it means to have a system in which those in power can silence people because they find their speech sufficiently hateful. So it's not a matter of whether you can identify something as the Bill of Rights when you see it. It's what people come to think about it.
To what extent is this dependent on the quality of leadership and the ability of leadership to articulate those values? I mean, it seems to me that the Bill of Rights always, when it's at the shining moments, it's because somebody, like a Supreme Court Justice or the President of the United States or someone, has articulated compellingly what that value is.
Well,
and it's not just dependent upon the people somehow to occasionally rise up and pay some kind of homage to the Bill of Rights.
Well, flag burning is a great example. I mean, I think happily the attempt by the president to wrap himself in the flag did not result in a flag amendment. But it was touch and go for a while. And if the country hadn't bought time, if there had been a stampede to vote on the amendment right away without any possible statute, you never know what would have happened. It seems to me that the lack of leadership by the president on the fact that what the flag stands for is the right even to destroy the flag was very dangerous. Interestingly, by the time the Supreme Court visited that issue the second time, more and more people sort of calmed down. And more people came to think that what was really important was whether we burn the Bill of Rights and not whether a few characters burn the flag.
Yes, sir.
Picking up on something Professor Tribe said about the homeless person and the recognition by the Supreme Court in Connecticut of that this wasn't a house. I think in a way it illustrates what I see as a problem about an approach of a lot of people to the Bill of Rights. Even though I see this as a positive decision, an important decision, wouldn't it be even more positive if there were recognition of a right to affordable housing or shelter of some sort, especially for people who end up having to live under bridges? And what would any of the members of the panel have to say about adding, if necessary, the right to housing, affordable housing, the right to health care, the right to a guaranteed minimal income, perhaps, a job, things of that nature?
How would you enforce it? I mean, that's the thing that bedevils me as someone who believes that it's outrageous for the government to sit by while some people starve to death and others freeze. The thing that keeps bothering me is if you write into the Constitution platitudes about how everybody should have a job, how medical care should be a right and not just a privilege, might that not, in effect, demean the value of those few rights, however modest, that can be meaningfully enforced, like the right not to be tortured into confessing? In Central Europe, it would be unthinkable now for any of the new constitutions, which are largely modeled after ours, not to include provisions of that sort. The right to decent medical care, they include typically the right to a healthful environment, the right to employment, and so on. But what's to happen when, in the transition to free markets, there is significant unemployment? People without jobs are then going to go to court and say, but I have a right to a job. And is the court then going to dictate a massive shift in allocation of resources? Most of those constitutions end up, therefore, having plainly unenforceable rights. And I'm really not so sure it's a great idea.
Well, if I could briefly respond to that, I would think in the same way that other rights that are very difficult for most of us to enforce are, when they are enforced as, for example, a safe work environment. I mean, you have to go through a process, but because we find that it's difficult for it to be enforced, we don't say there shouldn't be a right to a safe work environment.
Yeah, but statutes which can draw lines and establish practical solutions are one thing. Okay. Writing into a constitution basic principles that will be enforced against the will of the political branches or against the inactivity of political branches, that's where I would draw the line.
Thank you. Marty?
Actually, Professor Tribe, you just mentioned the Eastern and Central European countries enacting constitutions with a lot of provisions that we know probably won't be enforced. And transferring that to the American context, it seems to me that Ms. Kennedy's book points out very clearly that we already have provisions in our Constitution that aren't being enforced. Now, the answer may be that that's only marginal or whatever, but the fact is that that's happening. We see it in TV. We saw it on TV in LA. Now, as a student at the Kennedy School, interested in public policy, what I'm really interested in now is the next question. What do we do about that? You've kind of alluded to it with the issue of education, but I guess I'd like to address to Ms. Kennedy as well as to other members of the panel the question of, all right, where do we go from here? What are some concrete things that we can do to try to ensure that the rights we have, and this is assuming that we all agree with them, but on that basis, what concrete things can we do to try to make sure that these kinds of transgressions don't happen? I guess Judge Breyer might also want to talk to that.
Why don't you go ahead and talk to that?
Concrete.
Well, one thing you said was assuming we all agree with them, and that's, I think, the way the Bill of Rights is set up. It provides, as you know, for a discussion, and there's a lot of things that people don't agree on. So it's in some ways, that's a very big assumption to make. I don't have a lot of specific suggestions about your larger question. But I would say, I guess, that the Bill of Rights doesn't just, it sets up the structure, and it's up to us to enter the process and speak up and speak out. And I think there are people that are doing that, and the question is, I think that oftentimes we just sit back and let them do it for us, and that's not good enough.
I mean, I don't have a concrete thing. You're talking about what can the people in the room do. I mean, one is tempted in the university community to say, well, think. Now, why do I say that? Because after all, the Bill of Rights themselves don't, as you've pointed out, as we've all pointed out again and again, they don't embody every good thing. They don't embody but a small subset of all the aims that people might want, even in respect to government. But they do represent thinking on the part of the people who wrote that document that these were matters that A, were very important, and B, they could prove practically enforceable. And therefore, when we get into discussions about all the possible good things, and believe me, there are so many more than just the Bill of Rights, it's important to make distinctions, to think. And when you see the policeman who beats up somebody, you think, I'm going to try to stop that. That's of an order of magnitude that is even different from a person robbing your house. And then think of all the reasons why that's so. So I'd say create the hierarchy, think about it, reflect it in your conversation, and when the next person is tempted to give a speech, and you think that that speech embodies ideas that you hate, say, okay, that's his right.
Let me try to be a bit more concrete. It strikes me that the Los Angeles incident is a moment of opportunity for the country. That is, there was a moment when a window was opened on a set of practices undoubtedly quite prevalent, with respect to which there is a fairly deep consensus that it's outrageous and unconstitutional. I would submit that this is the moment, less for enacting a Civil Rights Restoration Act of 1991 and reenacting the debate about quotas yes or quotas no, than for enacting a remedial statute, an act of Congress, the Bill of Rights Enforcement Act of 1991, elaborating a set of concrete procedures and remedies. You can't expect Los Angeles to do it alone. You can't expect Boston to do it alone. Individual cities are going to be under enormous local pressure not to put in place engines of oversight, ombudsman, civil rights remedies with statutory minimum $1 million per egregious violation fines against the city that allows it to happen. I mean, I don't have the draft in front of me, but it seems to me that there really could be a coalescence of energy around a federal statute enacted pursuant to Section 5 of the 14th Amendment, which gives Congress undoubted power to do it, to put teeth in the Bill of Rights, because the teeth that are there now are they're weak dentures. I mean, what happens is that in many cases, the only way you can enforce a provision of the Bill of Rights is to let some guy who's murdered somebody out on the street. And that's something that we're reluctant to do. It gives the Bill of Rights a bad name. It seems to me that a far more dramatic and direct system of enforcement ought to be high on the national agenda.
Yes, sir.
I would like to enlarge the question Judge Breyer raised about the Ninth Amendment to the whole question, which I understand Justice Brenda saw as the penumbra thrown on the right to privacy or right to be left alone, which I feel is being violated in such a massive way, which people don't even notice it. One example, very quick examples, one from government to private, but the private sector is so powerful that people have no protection. One is the whole credit industry. I still remember within my memory, 25 maybe years ago, you would ask 1 or 2 references if you wanted to open a charge account. If you choose to be part of a network of credit cards, well, it's up to you. But from what I understand, everybody is covered. It's massive invasion of privacy in a way which Stalin's Soviet Union didn't have because they didn't have the technology. The second is the insurance industry. Very few people know it, that insurance pools. I happen to be a psychotherapist. Insurance insists on the right of people to reveal the most intimate information. Some insurance systems, every 8 weeks a report. People don't have to agree to it, but then they have no insurance. When they join a company, they don't have a choice to say, I don't want this system. And finally, the IRS. The IRS is a giant confronting individual without effective ombudsman system to protect. If you are very rich, you can hire good tax lawyers for $10,000 and up. Otherwise, IRS presumably makes mistakes at least 30% of the cases. The individual is helpless with the right to invade bank accounts, safe, much more than any private creditor, with no effective system for the small man to protect himself. Those three areas, which are three major examples, are massive invasions of the right to be left alone. Yeah, we could have, for example, revenues, graduated federal sales tax, where there will be no contact between the individual and the thing. Value-added tax. There are other ways. Insurance companies should have to reveal it in front in red big letters. Your privacy will be violated if you ask for other medical special psychotherapy services. It's not being done. And I would like both you and Professor Tribe to react to those massive violations that most people are not even aware till they touch them.
Can I ask, may I ask Caroline Kennedy to just respond to the, not to the IRS, respond to the question, how often did these kinds of issues come up when you were on these talk shows all over America?
Actually, tax comes up a lot.
Really? And what do they say?
A lot of similar things to the questioner here. It's something that I think is a big concern. The right to privacy generally, but specifically the power of the IRS is something that we heard a lot. And we just said it wasn't specifically covered by the Bill of Rights, and I'll turn it over to the professors.
Well, I mean, as you point out, increasingly the threats are not from government as such. That is, the largest data banks at the moment, though I don't know that we are fully familiar with the magnitude and depth of government data banks, the largest ones with which I'm familiar are run by places like Donnelly and CompuServe and American Express, and something like 90% of the people in the United States have an elaborate dossier on them listing their purchases, their places of residence, their social security number, their income profile, and it starts when you're born. That is, right now in most hospitals, a picture is taken at birth, and various questions from the hospital's records about the family are fed into the computer, and lo and behold, in a few months, the family starts getting advertisements about particular kinds of diapers and particular kinds of baby food based on the profile that is already growing. Now, in an information age, when the relative cost of collating all of that disparate information is enormously low, one of the few possible sources of protection, but as all of these elaborate cases about hackers sort of breaking into military data banks show, it's not so easily done, is that the footprints of the privacy invader are more easily tracked through the computer than they might have been in an earlier era. And fairly massive statutory protection. I don't think we can rely on constitutions to do it, but fairly elaborate statutory protections for privacy so that when information is given for one purpose, it isn't easily assimilated and used for another, I think are indispensable. But no society has figured out quite how to do it. Europe is way ahead of the United States on it. That is, in most of the countries of at least Western Europe, there is far more effective statutory privacy protection from the massive agglomeration of data that you describe than we have yet in the United States. But as with my suggestion of a Bill of Rights Enforcement Act of 1991, I think that in this area and in most of the areas that I can foresee in the next decade or decade and a half, the solution is an energized legislative process. Partly because general principles can carry you only so far, and partly because the judges that we now have are not particularly enthused about carrying us even that far. I would suggest that the solution is on Capitol Hill and in the state legislatures.
Stephen, did you want to add to that?
You're talking to a man who, when he goes up to an airline counter and has his name in the reservation system, I break out in a cold sweat. Right? I mean, no one likes the IRS, and the only reassuring thing that I know of as far as computers is concerned is that I regularly get invitations to meet with the President of the United States, possibly addressed to me personally, provided I send $5,000 to the Republican Party. That comes in with my name on it. So, all right. They don't work perfectly. All right. Just saying. All right. That said, all I can do is agree with your statement of the problem. Of course. Conditions change. There are serious rights of privacy. Some of them involve the government. The cases will work their way up. There will be violations of people's basic privacy that we all understand, whether they're Republicans or Democrats or vegetarians, whoever they appoint to the bench. They're human beings. And whatever their party affiliation, they can see and sense when something basic to a human being has been interfered with. And just a prediction about the future. You know, Yogi Berra says, I never make them. Okay, not about the future. But the point is that you will find cases arise where something fundamental has gone wrong, and judges will recognize that, and they will, I would predict, give a certain amount of protection, and maybe, if we're lucky, that will serve as a model, as in the free speech area, even without a law, as to what correct behavior is in the case of private institutions, individuals, enterprises. That's very optimistic, but we've seen things like that happen in other areas protected by the Bill of Rights. We've seen other rights recognized. We've seen other changes. And as long as you do have human beings running government, bad things can happen, but also good ones. So I am fairly optimistic.
You're up, sir.
Yes, I'd like to ask the panel to comment on an issue that's been in the news recently with the Milwaukee case and thrust really into the forefront with Bush unveiling his education reform package last week. And that's the issue of school choice and how providing federal funds for kids to go to parochial schools, does that compromise the separation between church and state? And referring to what Professor Tribe said about rights and responsibilities, I would like to ask the panel to comment, and if it does indeed compromise the separation between church and state, does that outweigh the responsibility of the federal and state governments to provide each child in this country with a solid education?
Don't look at me. I'm not
I think this is a good occasion really to remind ourselves that something may be a good or a bad idea and may nonetheless, well, something may be a terrible idea but be perfectly constitutional. Right away when the president proposed this choice scheme, I started getting calls from my Democratic senator friends saying, some of them, let's just say, asking, doesn't this violate something in the Constitution? And sort of my immediate reaction was, you know, don't always hide behind the Constitution. If you think it's a lousy idea, explain why. No, I do not think it violates the separation of church and state. You described it as though it's a kind of covert plan for funneling aid to parochial schools. But honestly, that's, though one of its side effects, that's also a side effect of providing police protection for kids when they're on their way to parochial school. I don't think that's either the main purpose or the effect. I don't think there's anything unconstitutional about a voucher scheme that's very broadly based. It may destroy public education. It may be bad in various ways, but I don't think it's unconstitutional.
Doesn't that go to one of the larger questions about just the quality of political speech or the quality of political debate today? It seems to me that this question of always running to the Constitution, or when the opposition or when somebody in public office proposes something you don't like, it's you go to their morality, or you try to ferret out, you know, what is wrong with those people, as opposed to having a decent point of opposition. It seems to me, and maybe as an elected official, Sheriff, you could respond to this, that the quality of political debate, not the availability of free speech, is the real issue we're struggling with today, and that is there is no opposition. People are afraid to engage or unable to engage in a kind of higher level substantive political debate, but instead have to accuse the other person of being either morally wrong or somehow unconstitutional.
I've experienced that myself with respect to with respect to education. Just to use that as an example, I have inmates from Boston who are products of the Boston public school system, who have gone to the 10th grade on average, who average about 20 years, 3 months, but they can only read at the 3.8 grade reading level. They are, in effect, functionally illiterate. So I filed legislation last December calling for inmates to go to school mandatorily, a mandatory 90-day sort of curriculum which would focus on their disability, because there are direct ties between functional literacy and recidivism. Nobody had to tell me that. I can see it. And individuals who don't have much else to do except watch TV, and rather than have them bust rocks, I thought it was important to have them go to school. So it's an interesting dialogue that's evolved from that.
Good. Yes, ma'am.
I'd like to raise a question that Professor Tribe alluded to, and that's when issues of national security come in conflict with issues in the Bill of Rights. More particularly, though, I'd like to ask you to address when the national security issues are within the United States. For example, during the Cold War, when the government was saying that that communists were infiltrating and that they had to be shut down. And first, I'd like to address it to you as the sheriff, as a law enforcement, enforcer. Do you feel that it's your responsibility to accept when the government says there's a national security issue, or do you believe that you have to decide that for yourself? And then I'd like to open it to the other panelists and ask how they view the issue.
Well, the classic case is when an inmate comes in, he gets booked in, and the big brother is certainly watching. And we have who we think is an individual who could possibly violate national security, and the FBI comes down and says, oh, by the way, Sheriff, could you maybe slip us a piece of his hair, because we want to take a look at that, because we think that might lead us to some other particular crime. Now that in and of itself is a violation of the Fourth Amendment. And if I participate in that act, I have now participated in an act that's violated that person's constitutional rights, for which I could be prosecuted federally for and sued civilly for by that particular inmate. So I definitely find myself in a position of compromise when individuals representing either the federal government or the state district attorney's office or any place else come in and ask me for certain evidence that maybe somebody botched at the scene of the crime or whatever. So I definitely have to make that second-tier assessment before I'm willing to cooperate with the police authorities that come in to ask us to assist them in that way. So I understand what you're saying.
Well, national security can sound so awesome that it can be a kind of conversation stopper. And one of the hardest things for anyone to do, and certainly for any court to do, as I'm sure Steve would attest, is to have the confidence of saying, well, although the Secretary of Defense or the Secretary of State tells me that the national security requires doing X, I won't go along. Now, occasionally, the Supreme Court has the backbone to do that. In the Pentagon Papers case, it refused to accept blanket claims of national security. That's probably the exception rather than the rule. There are harder cases. I mean, one that's discussed in Caroline Kennedy's book is the progressive case, where someone says, I've got the designs for the hydrogen bomb, and I'm going to publish it. And the Secretary of Defense and the Secretary of State file under seal documents with a court saying, if this stuff is published, although it's technically available in the public domain, it will accelerate the proliferation of thermonuclear weapons and increase the probability of global annihilation. Now, what is a judge to do? Say, well, let's see, 1% chance that the world will blow up. I'm willing to take that chance in the name of the First Amendment. Very, very difficult. Now, if you really believe in the First Amendment deeply, you would say, oh no, I think keeping this stuff secret is also likely to make the world blow up, because it will prevent people from recognizing how great is the threat of thermonuclear proliferation and prevent them from acting on it. But to act on your convictions in cases that really seem to implicate the national security, I think, is probably one of the hardest things for any judge to do.
Stephen, did you want to
I just can't resist telling you, because I told you that I clerked for Arthur Goldberg when he was a justice of the Supreme Court. And one of the stories that he liked to tell quite a lot was after he had left the court, he one day was having lunch with Allen Dulles, who was head of the CIA at that time. And he went over, I forget where, they were having lunch in Washington. And in the middle of lunch, a person delivered an envelope that was about this big. And Dulles opens it up, and there's another envelope inside, and he takes that out. And he opens that up, there's a third envelope. He takes out the third envelope and begins to read it. And he looks over at Justice Goldberg, and he says, "Arthur, do you know what this says?" And Goldberg said, "Yes, I do." He said, "You do?" He said, "What?" He says, "De Gaulle has died." He said, "My God, that's incredible. How did you know?" He said, "I heard it on the radio." That's it.
Yes.
I think one of the things that we like to do is think that civil rights violations only occur in El Salvador or Nicaragua or perhaps South Africa. And I'd just like to say that I don't think we have to look very far for pretty serious civil rights action or violations. I represent the Street Artists Guild, who are a bunch of street performers who perform here in Harvard Square predominantly and elsewhere. And I can't describe to you the civil rights abuses that these people suffer on a daily basis. I can't tell you how many times I have personally had to intervene and rush out of my home on a Saturday or whatever to prevent the arrest of these people who are exercising their First Amendment rights. I'm here tonight with a performer who was threatened with arrest for standing on the corner with his guitar in hand. He hadn't even started to play yet. And I want to say a couple of things about this. And the first is that we really need some accountability. We need some accountability from the police, and we also need some accountability for the judges who we as lawyers turn to enforce these rights. I don't think that anyone in this room would probably quarrel with having watched the police in LA beat that person. That was a pretty terrible thing. But I can bet you a nickel that that wasn't the first time that those cops had abused somebody. And I want to say to the people in this room that if you're abused by a cop, you should report it. I'm not saying that you should sue somebody, but what I'm saying is that small abuses need to be reported, and that's something that I think you as a common person can do to get some accountability. I want to just talk about judges for a minute, because I think that...
Quickly, because we're starting to run out of time.
I just want to say something, and that is that I can't tell you how frustrating it is and how upsetting it is to go to a federal judge and with blatant violations of civil rights and have the judge say to you, I went for an injunction for violation of civil rights, and the city had agreed that the ordinance was unconstitutional or that there was problems with it and that they were going to change it. The city had also agreed not to enforce the ordinance, and yet they kept getting threatened with arrest. I went there with photos, etc., and the judge said his question to me was, "But Ms. Stallone, do you really want to embarrass the city?" And my response to that is, I don't know when embarrassment to the defendant has become, part of the constitutional analysis. And as a lawyer, we're always told you can't criticize the judge. And a small part of you dies when you finally get to the judge and you've done your work and and the people are looking to you to enforce their rights. And you get to the judge and you realize that nothing is going to happen. And when you get to the judge and the judge says, on another case, "I'll sweep this whole thing under the carpet for $200. And I say, "Your Honor, we'd like that's an exact quote. "Your Honor, I'd like a jury trial." And he demands of my client, "How much are you paying this lawyer?" For example, as if to say, wouldn't it be cheaper for you to just plead guilty? These are serious problems. And I think that, lawyers are told, hey, don't say anything about the judge. And I think we need some accountability. And I'd like to know what suggestions you do have for getting some accountability, and what is a person to do when they can't turn to the judiciary and they can't expect the police not to lie about the little things.
Judge?
Oh, I think you should criticize judges. Absolutely, I would. I mean, I don't think there's any immunity from criticism. And indeed, if you find cases where you think the judge is not behaving correctly, I think you have that same obligation that you would say people have on the behalf of the policeman. You ought to criticize it. There are places you can criticize it. It isn't just the newspaper. There are bar associations. There are all kinds of institutions that, for example, in the federal court, every citizen in the United States can file a complaint. There's a complaint system that's set up that goes to judges who weren't involved. Anyone who has a complaint ought to follow that. I would totally agree with you that they should not be immune from criticism. There are procedures like the complaint procedure, and you ought to follow it.
Yes, sir. This will need to be the
I
last
assume
question. We
this
have to
would
be out by
conclude
9:20.
it, so I'm just going to tell one thing which illustrates rights beautifully, told to me by a rather well-known lawyer, but better known as a linguist, 17, as an attorney, not a judge, as a great scholar, a graduate of Princeton, and
Couldn't have been that great.
and just a moment, I will conclude. And also, as I've forgotten you, you drove it out, so I'll come to the point. He told a story which illustrates rights so beautifully. The scene is London. We're at the box office of a moving picture theater, and a chap very foolishly rushes in and tries to hold up the box office. And Bobby is on his way, but the people are incensed, so they've got him down on the ground and they're moving in on him more threateningly than would usually happen in London, I would suppose. But the Bobby came along and said, here now, let the man breathe. So that's my little tale, and I would like to conclude by congratulating Harvard University on making such a good choice for its next president.
Thank you. Let me, as we conclude, and before I ask you to thank the panel for this evening, may I see a show of hands of those who believe that their rights are more secure today than they were 10 years ago?
10 years ago, I don't know about the same.
Then, I'm sorry, did you not hear the question? Well, in the last decade or two, let me just ask, in the last 2 decades, are your rights more secure today than they were then, in your view? How about a show of hands, okay? Not very many people. How many would say that they feel that their rights are less secure today than they were, say, in 1970?
1970? No, they're not.
Well, it's 20 years.
Yeah, that's all right.
And how about 1920?
Yeah. Well, I don't know what that proves, but that was interesting, and I think the panel was very interesting tonight. So thank you all very much for being with us, and thanks to the panel.